Good morning to you all, one and all. This is Vibhur Kaur. I'm on behalf of School of Media, Films and Television Studies. आज हम लोग यहाँ एकत्रित हुए हैं एक ऑनलाइन फॉर्मेट पे। एक हमारे पास बहुत ही खूबसूरत सब्जेक्ट होता है IPR, इंटेलेक्चुअल प्रॉपर्टी राइट, और टॉपिक हमारा क्रिएटिव माइंड्स एंड IPR। इस पे हमारा आज का वेबिनार, जो हमारा नेशनल सेमिनार आज का शुरू हो चुका है, जिसके लिए मैं सबसे पहले इनवाइट करना चाहूंगा हमारे प्रो वीसी सर, प्रो वाइस चांसलर डॉक्टर सुनील दत्त शर्मा सर, IIMT यूनिवर्सिटी से। सुनील सर इज a renowned academician, researcher and administration professor. Sharma has more than 42 years experience, और सर ने सर के निर्देशन में 14 और 75 से ज्यादा रिसर्च पेपर सर के नेशनल लेवल पर सेलेक्ट हो चुके हैं। एंड सर के अंडर में 34 PhD अभी तक हो चुकी हैं। और उन सर को, यानी सुनील सर को, गुरु द्रोणाचार्य अवार्ड, राधा कृष्ण अवार्ड, भोजपुरी गौरव अवार्ड से सर को सम्मानित किया जा चुका है। अब मैं सर से ही रिक्वेस्ट करूंगा कि सर आज के प्रोग्राम को एक बार थोड़ा सा एक्सप्लेन करें। प्रो वीसी सर सुनील दत्त शर्मा सर।
Thank you, Mr. God. And first of all, would like to congratulate the School of Media, Film and Television Studies, IIMT University Meerut, and especially the Dean of the department, Dr. Ravindra Rana, and the HOD of the department, Mr. Vishal Sharma, who has organized the national seminar in collaboration with IPR Promotion and Management, Ministry of Commerce and Industry, Government of India, and also the collaborating agencies, the distinguished guest, Ms. Ruchita Singh, Manager, CIPAM, Department of IIT, Ms. Kajol, Assistant Manager, and Ms. Charu of the same department. They had organized the program on the occasion of National Technology Day. So on this occasion, I welcome all of you on behalf of IIMT University Meerut. And the topic which is chosen by you is very relevant nowadays, because IPR, copyright, trademark, these are the things which are now very familiar words, which in the society nowadays, after when the government of India has taken a step, the program Make in India and Startup India. There are two things of the seminar. The one is the creativity and second is the intellectual property right. Creativity is defined as tendency to generate or recognize ideas, alternatives, or possibilities that may be useful in solving problems, communicating with others, and entertaining ourselves and others. Creativity is the ability to come up with ideas both general and unique. It creates new types of knowledge that is useful for the world. Actually, हम सब लोग एजुकेशन के फील्ड में काम करते हैं और उस एजुकेशन के दो पार्ट हैं. एक है that is the purely theoretical aspect of the classroom teaching, and the another part is the practical aspect of the teaching, in which we send our students for summer training in the industries. And most of the time the student complain that they are not accepting by the industry. So then why they should accept you? Because you don't have that knowledge which is required or which is the requisition of that particular job or the industry. That's why you have to create an idea that must be unique. In what way it may be unique? Whether it may be the modification of the existing ideas or the existing product, or it may be your idea which is unique one, it is nowhere established right now. तो इस तरीके से हम दो तरीके से चीजों को करते हैं. एक तो हम अपने उन विचार से, अपने उस आइडिया से, न्यू टेक्नोलॉजी से हम या तो कोई नई चीज बना सकते हैं या जो एग्जिस्टिंग हमारा प्रोडक्ट है या एग्जिस्टिंग चीजें हैं उनको हम मॉडिफिकेशन करें, और मॉडिफिकेशन किस तरह से कि टाइम सेविंग अगर हो सकता है, कॉस्ट सेविंग हो सकता है, देन इट मे बी योर यूनिक आइडिया. Intellectual property right are the rights given to a person over the creation of their minds. आप क्या सोचते हैं, आप क्या करते हैं, ये एक अलग बात है. लेकिन वो अगर आपका आइडिया किसी एक ऐसे प्लेटफॉर्म पे जाकर रिकॉग्नाइज होता है जिसको सोसाइटी और जिसको नेशन या जिसको वर्ल्ड वाइड एक्सेप्ट किया जाता है, दैट इज नोन एज intellectual property right. Usually the creator an exclusive right over the use of his and her creation for a certain period of time. अब हम किसी भी तरह का कोई विचार, किसी तरह की कोई भी टेक्नोलॉजी लाते हैं तो वो कुछ समय के लिए उनका अपना एक यूनिक आइडिया हो सकता है, बट फॉर ए सर्टेन पीरियड ऑफ टाइम व्हेन दे विल यूज देमसेल्फ एंड that idea may be borrowed by the others too, and that will be the public, and that will become the intellectual property right. But intellectually property right are the right given to a person uh, over the creation of their minds, invention, literary, artistic works, and symbols, names, and images used in commerce. They usually give the creator an exclusive right over the use of his or her creation, as I had earlier mentioned, for a short period of time only. But in 1983, I think so, the protection of industrial property has come up in India. Sorry, in 1916, the idea is taken by the government of India, and they had adopted the intellectual property right in 1986 in May, I think so. There are some the ways or the types of the intellectual property right. Before that, I would like to include the importance of intellectual property was first recognized in Paris Convention of the Protection of Industrial Property in 1883. 1983 में पहली बार इसके संबंध में कुछ विचार किया गया, एक कन्वेंशन हुई, और उसके बाद 1986 में एक इसी तरह की कन्वेंशन हुई, और फिर जो दोनों ट्रीटीज थी 1983 1986 में are administered by the World Intellectual Property Organization. और उसी के बाद इंडिया में भी इस तरह की चर्चा होने लगी, और 1986 में ये इसको जो है वो 2016 में फिर हम लोगों ने ऑप्ट किया. अब इंडस्ट्रियल जो ये कॉपीराइट है, ये इंटेलेक्चुअल प्रॉपर्टी है, इसमें क्या क्या चीजें हम इंक्लूड करते हैं. जैसे अगर हम देखें कॉपीराइट या इंडस्ट्रियल प्रॉपर्टी राइट, तो इस तरह की कोई भी डिजाइन हो, किसी तरह के क्रिएशन ऑफ टेक्नोलॉजी हो, किसी तरह का कोई ट्रेडमार्क हो, दे ऑल आर द टाइप्स ऑफ द इंटेलेक्चुअल प्रॉपर्टी राइट. अब सवाल ये होता है कि व्हाट इज द नीड ऑफ इंटेलेक्चुअल प्रॉपर्टी राइट. तो अकॉर्डिंग टू मी, टू एनकरेज इनोवेशन. अगर हम किसी तरह के विचार को, किसी तरह के कृत्य को हम एक इनोवेटिव आइडिया के रूप में लाना चाहते हैं, तो डेफिनेटली हमें कुछ करना पड़ेगा, एंड दैट इज वन ऑफ द थिंग थ्रू व्हिच वी कैन प्रमोट द आइडिया. तो the need of the IPR is, number one, just because of to encourage innovation. Second, for the promotion of economic growth. Third, for the safeguard of the right of the creators. अब अगर हम लोग आज की तारीख में देखें तो रिप्लिकेट्स आपको इतने सारे मिल जाते हैं, एक चीज बनी और उसके बाद उसकी डुप्लीकेसी बाजार में आ जाती है. तो इसका मतलब है जिस व्यक्ति का वो विचार था वो किसी ने बिना वजह चोरी कर लिया, और उसके बाद उसके रिप्लिकेट्स हमारे को बाजार में मिलने लगे. That's why it is the need of the hour that if anything whether it's a dialogue, whether it's a music, whether it's a film, or any innovation, or the book, or the trademark of a person, and the creation of the person himself, that it should be licensed first. It is one of the problem in India that uh, the foreigners or the multinational companies are uh, protecting themselves to invest in India just because of one thing, because if they are coming with an idea, that idea may be replicate thereafter in India. That's why the licensing is one of the things through which we can protect the right of the creator, जिसने भी उसको बनाया है, और उस व्यक्ति ने जो भी उसका इनोवेटिव आइडिया है उसको कोई बारोड ना करे, यदि करता है तो उसकी मर्जी से करे. दैट्स व्हाई द लाइसेंस फॉर दैट इज नेसेसरी, और इसी के लिए आईपीआर राइट्स की हम बात करते हैं. It promotes innovation and creativity and ensure easy of doing business. बहुत सारी दफे आपने प्रधानमंत्री को सुना होगा कि ईज ऑफ डूइंग बिजनेस की बात करते हैं हम. तो ईज ऑफ डूइंग बिजनेस के लिए आईपीआर प्रोटेक्शन इज वेरी नेसेसरी. और जैसे मैंने बताया कि इंडिया में ये किस समय शुरू हुआ, और अगर हम इसको और क्योंकि ज्यादा विस्तार में नहीं जाऊंगा मैं केवल आपको कुछ चीजें कि भारत में आईपीआर की जो स्थिति है, या भारत में आईपीआर का प्रमोशन है वो किस तरह से हुआ है. तो वे फॉरवर्ड टू आईपीआर कि प्रमोटिंग एन एनवायरनमेंट ऑफ इनोवेशन इन स्कूल्स. किस तरीके से हम कर सकते हैं कि हम सबसे पहले जो स्कूल कॉलेज में देखिए, एक छोटा बच्चा जब होता है तो वो उसका माइंड इतना डेवलप होने की दशा में होता है इन कंपैरिजन टू ए पर्सन हु इज इन द पीजी क्लासेस और इज इन रिसर्च. तो छोटा बच्चा की एडेप्टेबिलिटी बहुत ज्यादा होती है. तो वी हैव टू क्रिएट एन एनवायरनमेंट इन द स्कूल्स थ्रू व्हिच वी कैन प्रमोट द IPR and promote some of the new researches, the ideas, the innovation, and we have to include this IPR in our course curriculum uh, uh, from the secondary schools. A proper resolution mechanism for resolving IPR related issues is needed. अगर किसी भी तरह की कोई समस्या होती है तो ऐसी स्थिति में उसको सॉल्व करने के लिए हमको एक बहुत जल्दी तरीके से एक ऐसा मैकेनिज्म हो देन एंड देयर जिसको हम वहाँ सॉल्व कर सकते हो. India will be unable to take full advantage of the transformation benefit of the strong IP system unless and until it addresses gaps in its IP laws and regulations. What are the things which the IPR system is blamed by some of the person, and just because of that we are not able to attract the number of people from outside. That's why we have to fill up that gap and to attract the number of person from outside. अगर मैं कहूं कि भारतवर्ष में आईपीआर के विषय में सबसे ज्यादा किस चीज की चर्चा है, या किस विचार की चर्चा है, या किस टेक्निक की चर्चा है, though we are approaching towards the 5 trillion economy, but contrary to that, we are approaching and we are marching ahead towards the 5 trillion economy, and contrary to that, the unemployment ratio is increasing day by day. So what to do, and why this situation has arisen? Just because we don't have the manufacturing unit in India, and we are a state which trade only. We success of India's flagship programs, that is Make in India and Startup India, depends upon the boost of innovation ecosystem with better IPR safeguards. मोदी जी बार बार इसको कहते हैं कि हमें एक मैन्युफैक्चरिंग हब बनाना है और हमें लोकल को ग्लोकल की बात करनी है, लोकल टू ग्लोकल की बात करनी है. We will make it the things in India, and we have to make the things in a way so it should be acceptable at the global level too. तो लोकल टू ग्लोकल की जब हम बात करेंगे तो मैन्युफैक्चरिंग प्रोसेस, मैन्युफैक्चरिंग हब बनेगा और हमें सबको खुशी होनी चाहिए कि आज की तारीख में भारत डिफेंस इक्विपमेंट में भी एक्सपोर्ट करने लगा. तो ये आईपीआर है. लेकिन इफ एनीथिंग इज मैन्युफैक्चर्ड बाय द डिफेंस गवर्नमेंट ऑफ इंडिया, that it can't be borrowed by any other country or any other nation or any other organization until and except this license is not given to them. तो इसी तरह का सेफ गार्ड हम चाहते हैं कि एक व्यक्ति मीन्स अगर डॉक्टर रविंद्र राणा इज क्रिएटिंग समथिंग, that thing should be his own only, and if anybody wish to uh, recycle it, if anybody wants to use it, then the permission of that particular person should be taken by the person who is going to use it. So इस तरीके से licensing, that's why there is a one of the protection must be provided to the creator, and that is the safeguard to that particular person through IPR. यदि हम ऐसा करेंगे तो ऐसी दिशा में और लोग आगे आएंगे. और इसके लिए हमें करना क्या होगा? We should be aware of that thing that should not be borrowed by the thing which is not licensed, and we should make aware to the students regarding the IPR ecosystem too. And Government of India efforts to strengthen national and IPR policy. Uh, right now, with the help of WTO, and an efficient and equitable intellectual property system can help countries to realize intellectual properties potential as a catalyst for economic development and social and cultural well-being. So with these words, once again, I would like to congratulate the IPR Promotion and Management Department, Ministry of Commerce and Industry, Government of India, and the School of Media, Film and Television Studies of IIMT Meerut, uh, and the entire team of the this national seminar, and especially the Dean, Dr. Ravindra Rana, and HOD of the department, Mr. Vishal Sharma. Thank you very much, and also the distinguished guest from the Department of IPR, Government of India. Thank you very much.
Thank you very much, sir. And I believe that whosoever is available in the seminar must have the clear view of the IPR, what IPR is. Sir has actually explained the subject in very detail and with all the technological terms. Thank you very much, sir. And this support was needed. Now I would like to welcome Charu ma'am. She is from Department of Promotional of Industries and Internal Trade, Ministry of Commerce and Industries. Charu ma'am is currently working for the cell of IPR Promotion and Management. Graduated from National Law University, Punjab, and pursued her master's in law in intellectual property from Queen's Mary University of London. She has written various papers of intellectual property and has developed an expertise in the subject through attending summer schools and conferences held by World Intellectual Property Organization, WIPO, Geneva. So Charu ma'am, we are very fortunate enough that Charu ma'am is connected with us, and thank you very much ma'am, because with the Department of Promotional of Industry and Internet Trade, we are organizing and having this webinar with us. So thank you very much ma'am. And now I will request Charu ma'am to please continue the subject. Thank you ma'am. Charu.
Hello, good morning all. Thank you for inviting me for the session and for the very warm introduction. So I would like to start with the presentation if everybody is ready and okay with it.
Yes ma'am, we are good to go.
Okay.
Yes ma'am, thank you ma'am. We are good to go ma'am.
Okay. So yes, so my topic is registration of trademark and advantages of IPR in creative works. So I will be starting. I would just like to say a few things before I start. That I would like to keep the session very interactive. So there are some activities and games included in the presentation. So I'll be really happy if everybody participates in that as well. And if you have any questions, you can just leave them in the chat box and we'll take them after the session is over. Thank you. So as the professor, he's already explained what are IPRs. So IPRs are basically creation of mind, like anything that comes out of that's produced by your mind is what intellectual properties are. So anything that's developed from your intellectual or your mind are intellectual property, and intellectual property rights are the rights that are given to the person who has created these IPs. So intellectual property consists of many different types of IPR, such as copyright, trademark, geographical indication, designs, patent, trade secrets, and etc. So I will be dealing with trademarks, but in the next sessions, you will also hear about copyright and patents, which are also very important IPs. So what are trademarks? So trademark is a distinctive sign which identifies the goods and services of one company from those of another. So this is just like a basic example of cola. So we see cola is a product, but when we see that there are two companies selling cola, Pepsi and Thumbs Up. So when we see Thumbs Up and Pepsi, we realize that these both are colas, but they belong to different companies because of their name and their designs, that is Thumbs Up and Pepsi. So they help in identifying goods and services of one company from another. Also, they also help in identifying the goods and services offered by a company. For example, you see there are many logos like Maggie, Samsung. So when you see Maggie, you instantly relate it with noodles. Or when you see Samsung, you instantly relate it with laptops or mobile phones. So that's what the trademark helps in doing. It helps you relate to that company, and it creates a bond between that company and the product. So also the trademarks are registered for 10 years, which means that you get it registered at the Trademark Registry of India, and then after 10 years it gets expired, which doesn't like trademarks are perpetual, right? Which also means that if it expires after 10 years, it can also be renewed. Like it can be renewed after 10 years, and then for another 10 years, and then another 10 years. It goes on like that. They're only provided for a duration of 10 years. So that's what's a trademark. And now trademark also has a different varieties, or different, like what can be applied as a trademark. So you can apply a symbol as a trademark, like you see a swoosh sign in Nike, that's a tick, that's a symbol, but you can use it as a trademark. Also the symbol of Mercedes, you see that 3 stars, that's also applicable, like can be registered as trademark. Then there are slogans like I'm loving it from McDonald's, and then Dar ke aage jeet hai from Mountain Dew. So these are all slogans, but they're also registered as trademark because once you hear the slogan, you instantly connect it with the company. So that's why you can also register slogans as a trademark. Then there are words like New York Times, or any word, like it has to be like any word that you can relate it with the company, that can also be registered as a trademark. Then there are sounds. So as when we were all kids, we used to see cartoons. So every time Tom and Jerry used to come up, there used to be a lion who used to roar in the beginning, and then the cartoon used to start. So that sound of the lion is also registered as a trademark. So you can also register a sound as a trademark. So uh, in the company called Moto, there's a sound called Hello Moto. That's also registered as a trademark. So you can also relate sound with a company. And then there are drawings, such as like you can draw anything, and then you can make a small picture of it and then attach it to a company or a trademark. Then there are numbers, like there's a famous perfume called Chanel number 5. So this number 5 is a number, but it's also registered as trademark. Then
am I audible?
Yeah, I can hear you.
आई थिंक आपका जो पीपीटी है चल नहीं रही है अभी, वो खाली रजिस्ट्रेशन ट्रेडमार्क पे ही रुका हुआ है. इन केस ऑफ लिंक इट्स नॉट रनिंग.
Okay, let me check.
अभी printed ही
But
चल
you
रहा
can,
है that
आप सुन सकते हैं मुझे, but आप देख नहीं सकते।
नहीं वो जो ट्रेडमार्क है ना अब दिखने शुरू हुए हैं, बीच में ट्रेडमार्क वगैरह चेंज नहीं हो रहे थे, नाउ ट्रेडमार्क
अब दिख रहे हैं।
अब दिख रहे हैं। अभी इस समय वो वाला वी कैन अप्लाई ट्रेडमार्क वाला।
Okay, 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 okay.
Sorry for that.
No problem, no problem. Thank you for telling me, otherwise I would have gone and on and on. All right.
Please continue, ma'am.
Yeah. So you can also apply a combination of colors as trademarks. So here you see that Starbucks has a color of both black and green, but it's a combination, and it has made a very unique design. So that can also be registered as trademarks. And interestingly, the colors can also be registered as trademark. Like Cadbury comes in a purple wrapper, so that purple color is trademarked in Cadbury's name. And then if you see Kit Kat, they come in red color wrappers, so that red color is also trademarked with Nestle. Kit Kat is a brand of Nestle, so Nestle has registered red color as a trademark. So you can also register signatures as your trademark, like Shah Rukh Khan, Kareena Kapoor, these famous personalities. What they've done is they've protected their signature as trademark. So nobody can sell any product using their signature. Like anybody can, like make a dress and then put their signature on below, showing that this dress has been signed by Kareena Kapoor. So this is actually prohibited. So if anybody does that, Kareena Kapoor can actually sue them and stop them from doing it. And then shape of goods, like any particular shape of goods can also be registered as trademark. Pictures are also registered as trademark. Logo symbols I've already explained, and then names also. Like actually, the trademark started as names only. So when there used to happen trade, and when people used to sell, like farmers or anybody who used to sell their products to other people, they would sell them in packages. So just so that they could distinguish their products to somebody else's product, they would write their names on it. So their names started becoming their trademarks. So that's how actually trademarks started. They started with names. So you will see that the very old businesses, they usually have their names as trademarks. So there are so many, like jewelry shops, they have their names in the trademarks. So names are very common trademarks that people use, such as Sabyasachi, that's a name, and Coco Chanel, Dr. Reddy, Dabur. Dabur was a doctor called Dr. Dabur. So these are all names that can be registered as trademarks as well. And then combination, I've already explained that any color combination that has created a unique design, that can also be protected as trademarks. So why are trademarks important? So I've already explained a little bit, but I'll go in detail that they obviously help somebody in identifying the goods and their origin with the company, and they create a bonding with the customer and the company. So it can be like, for example, say there's a company called Apple. They are making phones, but if they want to go into making, say, shoes, so because people have they've created such a bond with Apple, because that it's a good brand and it creates good products. So when they see that Apple has also released shoes, then they'll definitely will go and try to see it and buy it, that what has Apple come up with now. And because they have identified it with the name, they'll probably have a bonding and a trust with the company also. So they'll go and they'll also like try to experiment with the new shoes and everything also. So they also serve as a guarantee, and they also signify quality of the goods as well. And they are a great function of advertising or marketing tool. You can play with the logo and trademark, and you can advertise it very well. And obviously it creates an image in your head. The moment you hear like Maggie, you instantly think of noodles. So it helps you connect with the trademark, helps you connect with the product. And sometimes you love the product so much that you also develop a bond with the company as well. So that's why trademarks are important. And I'll also, like, here's a little game that I've made. So these are different brands, and I've changed their fonts and colors to different brands. So I've interchanged them. This is only to show you that the moment you see any brand, you just instantly connect it with the original brand. So even if you see Red Bull here, you will just instantly remember, like, it's not Red Bull, it's a sign of YouTube. So that's the importance of trademark. When you see it's Nike, you will definitely understand that it's actually IKEA. So if anybody is like, um, if anybody wants to take a go at it and wants to show what's what, they can put it in the comments and we can have a discussion. Anyways, yeah, you can do that, but I'll continue. So yeah, this is Gillette, but it's actually a sign of Google. This is Netflix, but it's actually Nescafe. This is Burger King, but it's like it's written Starbucks. So it helps us connect with the brand because we've seen it so much and we know it so well. This is Nutella, but it's actually Netflix. Like, I'm sure people can understand that. And now what should be an ideal trademark, and what should we avoid when when we are making a trademark. So when you're starting a business, you definitely want to have your own unique trademark. So what should you do and what should you avoid when you are thinking of registering a trademark? That is, that it should be unique in the sense that it should not be something very normal, like for example, if you're selling vegetables, you can't have a shop named vegetables. It's not unique and it's very generic. And that's actually also not like you're not able to register it as a trademark because it's so generic. So you should always come up with something unique, something distinctive, like Beam. It's actually a short form for four different letters. So something like that is also advisable. And then sometimes what people do is they make words, like they create words from, like, they'll mix two words, they'll ship two words, and they'll make a new word which does not have a meaning, but it sounds cool, or it sounds different. So that's also advisable. You can custom design your own trademarks as well, or you can make your own devices or symbols, such as Make in India. That's a symbol that we've created, Ministry of Commerce. And then non-descriptive, like you can't go for, like if you're selling cars, you can't go for a trademark such as fast, because that's descriptive. So it should be something unique and different and not related to the actual product. That's not advisable. So yeah, it should be. And what you should avoid in a trademark is that it should not be like it should not just be a verb or an adjective of what the product is. And it should not contain any kind of religious or constitutional words such as Ashoka Chakra, or any Om, or swastik, or anything like that. Common swears are also recommended to avoid. And obscenity is something that's prohibited by law, so that's also cannot be registered as trademark. And name of a person, because sometimes names are very generic. So if you can come up with, like, it's your right to have a name as have your name as trademark. It's also mentioned in the Trademarks Act, but it's generally like recommended not to make a name in the name as a trademark, because sometimes names are very common and you can get into a dispute very easily. Like Rahul Kumar will find lakhs and lakhs of Rahul Kumar in India. So that's something that's not advisable to keep as a trademark, because otherwise you may end up into legal trouble for someone else who has registered their company as Rahul Kumar. So yeah, what you should like keep in mind when you're selecting a good trademark is it should be easy to speak and spell. Like sometimes there are some foreign countries that come into India and they have these brands called Schwarzkopf or something like that. That's difficult to pronounce. So people generally, to like avoid embarrassment or anything, they just don't pick up that product, or don't ask for that product, or like you should have a trademark that's easy to speak and spell for everybody. And it should be easy to remember also, like it should not be a very long name or something like that. And definitely arbitrary words like so very common word like Apple. So it's actually a company that sells electronics, but its name is Apple. Similarly, there's a brand called Mango that sells clothes. So that's something recommended, because people would not it's not generic, first of all, because it's not like Apple company is not actually selling apples, they're selling something else. So that's actually recommended. and then Camel for watercolors, and Amazon, which is actually a forest, but they're selling products on online. And Kodak is a company for cameras, but it's actually not a name. It's a it's an arbitrary word. It's not actually in dictionary, but somebody has like made a word, Kodak. So that's also like a new word that is invented. That's also recommended to be registered as trademark. Then again, I've explained that what you should avoid as a trademark, which is like when you're selling chairs, you name a brand chair. In fact, there's a US company called Pots and Pans, and they in fact actually sell pots and pans on their under this trademark. So when they came to India, they applied for a trademark. Their trademark actually got refused because it's so generic. Like the trademark is pots and pans. They are selling pots and pans, so it's very generic. So that's why, because such trademarks are refused because it's a like everybody's selling pots and pans, and everybody would like to name their brand pots and pans, and that's not possible. That's why it's recommended not to use generic terms and come up with something new and something different. And yeah, descriptive terms I've already explained, like sweet to sell chocolates, or fast to sell cars, or sharp for knives and scissors, something like that, should also be avoided. And sometimes what happens is uh, you are using like you are decepting the consumer by using a term which is not actually related to the product, such as you're selling a synthetic material, let's say something nylon, and the brand's name is pure wool, so this is deceptive, and that's not acceptable. If you must have seen, there's a yeah, homemade, there's a brand called Homemade, and they are selling products that are not actually homemade, they're made in a factory, so their trademark is not registered actually. So yeah, anything that's contrary to public order or morality is also someone should avoid using as a trademark. And flags and armorial bearings and legal authorization terms that are used in constitution, and our emblem, national emblem, that's also something that's recommended to avoid. And one thing is that one should not use a trademark that's already in the market. For example, there's a very famous bakery in Delhi called Theobroma. So it's very famous. And then there's another bakery they opened up after Theobroma, and they named their bakery Theo's. So I don't know what their strategy was, but generally it's when you register a trademark which is very similar to an existing trademark, then you might get into a trouble. And that's what happened with these two bakeries as well, because Theobroma filed a case against Theo, saying that it's very similar to Theobroma, and people would think that this is a brand of Theobroma, and people would go to Theo's and not come to Theobroma if because they would relate these two to each other, that they would think that this is the same brand. So actually, the case went to court, and the court decided that there was a settlement between these two bakeries, and they decided that Theo's will only function in Delhi, and Theobroma can expand in the whole country as they like. But Theo's, because they wanted to keep the trademark, they signed an agreement with Theobroma that they would only stay in Delhi, and Theobroma can expand as they have in Mumbai and other cities. Okay. So there's also so trademarks are divided into 45 classes. So what happens is that you can trademark is generally given protection under one class, one sort of class. So for example, there's a car company called Jaguar, and there's another company that makes bathroom appliances called Jaguar. So these are two different classes, because the car companies, they are focusing on a particular class of consumers which are focusing into cars, and the Jaguar is focusing on bathroom appliances. So you should also keep in mind that if you want to expand to other classes as well, so you should get your trademark in all the classes. So trademarks are only, you can only get it registered as it into a class. For example, if I open a brand called Sugar, and I'm selling shoes, and if somebody else wants to open a brand called Sugar and they are selling clothes, then that's okay. I cannot go and tell them that you cannot use this trademark because you know I am using sugar for my shoes, because these are two different classes, and we are targeting different types of people. Like I am targeting people who are interested in shoes, and the other person is targeting people who's interested in clothes. So I cannot ask them to stop using sugar for their clothes. So you should always keep in mind that trademarks can only be protected in a particular class. So you can see there are 45 different types of classes, from goods to services, whatever, wherever you would like to protect your brand, you can just see what class you want, and then you can protect it there. Also, trademarks are territorial right, which means that if you have a business in India and you want to protect that your trademark in India, then it will only be protected in India. If you want to protect in any other country, then you'll have to go to that other country and then protect it there. So you should always keep in mind that trademarks are territorial. You cannot go to another country and see that your brand's name is being used there, and you cannot stop them because you have only protected trademark in your own country and not in another country. So that's also something to keep in mind. After that, I've actually, this was a little game, but because the slideshow is not working. So yeah, so this is a puzzle, and if you can see any famous trademarks in here, you can write it down in the comments. And like there are many famous trademark names hidden in the puzzle, if you can see and put them there.
Ma'am, there's Dettol.
Yeah. Anybody else?
Amul is there, ma'am.
I see Amul. There's Amul on the top track.
Lux is also there, ma'am.
Yeah, there's Lux. So there's also Cadbury here if anybody's can see it. And
Yes,
there's
ma'am, in the second row.
yeah, there's Cadbury, and this is Babool. And yeah. So moving on to the next slide. Yeah. So trademark is it's a very common IP that's been infringed very commonly. So there are three types of infringement that take place in trademark, which is like counterfeit, which is like 100% copy, and people just like they are deceived into thinking that sorry they're deceived into thinking that this is the actual genuine product, and they buy it for the probably the original price of the product, but the product is actually counterfeited, which means that it's actually a duplicate and not the original. uh, okay, and then I'm so sorry, I just have to quickly. So second type of infringement is piracy, which means that the consumer knows that this product is not real, but they still buy it because they can't afford the original product. So there's a difference between counterfeiting and piracy. Counterfeiting is when people are deceived into thinking that this is the real product, and piracy is when people think that this is actually the fake product, but they still buy it because they know that they cannot afford the actual product. And the knockoffs are something that you must have seen on a regular basis, like the water bottles, the actual name is Bisleri, but somebody exchange the letters to and make it Bilseri. And then there's very famous Reebok and Adidas Abibas. It's like very common and people have seen it everywhere, but because they just change the words a little bit, letters a little bit, and the font and everything is same, so people either not notice it, or they still buy it because it looks so much similar. So that's something that people sometimes they know that this is wrong, but they still buy it. So that's also one of the aim of intellectual property to build respect for IP, to understand that trademark infringement is actually unethical and it should be avoided. Even if you cannot buy a product that's not genuine, then maybe you can buy for something that's cheaper and local, and it doesn't have to be a pirated product. So it's very important to build respect for IP as well. Like, you understand that this is a fake product and you still buy it. So yeah, it's very important. Like, it's one of our goals to build respect for IP as well. And then how can you register trademark in India? So trademarks, again, they are territorial rights, so you have to register it in India. And actually, under the trademarks are governed under the Trademarks Act 1999, and it also has a set of rules which are called trademark rules. They keep on amending from time to time. So last amendment took place in 2002. So the Trademark Act, in along with the trademark rules, they function together and they protect the trademark rights, and like they give you the protection of trademarks. And under the Trademarks Act only, the trademark registry was established in India. So there are 5 trademark registries all over the country. The main head office is in Mumbai. Other 4 registries actually cover the 4 regions of the country. So one is in New Delhi, and then another is in Ahmedabad, then the third one is in Chennai, and then in Kolkata. So it's if you want to get your trademark register, you'll have to go to the trademark registry to register your trademark. Now, what are the steps for registering a trademark in India? So first of all, first and foremost thing is to select a good trademark. So you can come up with the name and any color combination, any logo, drawing, picture, anything. But like anything that you relate to or you resonate with, a good trademark is important. And then there are also different forms and fees for people. Like, there's a different form for if an individual wants to register their trademark, and if a company wants to register their trademark, if a group of people want to register their trademark. So there are different forms for everybody. So you have to first identify which is the appropriate form for you and what is the appropriate fee for you. So basically, the fee ranges from 4,500 to 9,000. 4,500 being for the individual and 9,000 for a company or a business. And then after that, you need to figure out which class. Like I said, that there are 45 classes of trademarks where you can register your trademark. So you need to identify which class suits best for your trademark, like which goods and services are you going to provide under this trademark. So you need to apply under a specific class. Then you need to go to the trademark registry. You submit your forms and fees and everything. And then what happens after that is the trademark examiner, they conduct their own search on the trademark. They search it on the trademark registry website, and they try to find out if there is a similar trademark already registered for that for your application. So if that happens, then they write to you and they tell you that this is already registered, so you need to change it, you need to modify it a little bit. So what's recommended is that you should always respond to the office, whatever the trademark registry is asking you, any queries or any notices that are coming to you, that you should always just reply on time so that you can get your trademark on time. So yeah, you can also carry out your own search for the trademark. For example, you've come up with a very creative and very innovative trademark for your brand, but you need to be sure that you are registering it. So what you can do is you can go to the trademark registry website and you can conduct your own research before you go to the office, so that you are sure that your trademark will be registered. So you can put it in different classes. You can also like put the word mark, and you can also put the pictures of what your trademark looks like. So if there's any similar picture of a trademark that's already been registered, that will like when you search it, it will come on the page, and you can see and review for yourself that if there is a trademark that's very similar to your own trademark that you are going to register. So the clearance search is something that one should always do before they're getting into the process of getting a trademark registered, because it's a lot of hassle to actually change it and after you've applied for the trademark. So it's better to do your own due diligence before that. And in the forms, for example, there are some basic requirements that you need to provide to the registry. That is your name, like legal status, as in what's your legal status and your name and full address. And there's one requisite of trademark that you should always keep in mind is the representation of trademark. So if your trademark is not graphically represented, that means like if you cannot put your trademark on paper, then you cannot register it. For example, there's a new concept of smell marks. So smell marks are something that that's something that you smell it and you associate it with the company. So this is a very up and coming trademark and it's not yet registered in India, but it's not registered because you are not able to represent it graphically. You cannot put it on paper. That's why you cannot register it in India. But in other countries, smell marks is a new trademark and that's been getting registered. So I'll give you an example of smell marks is that if somebody has gone to ITC hotel, so when you enter the hotel, you smell a different sort of smell. That's like they have this common smell in every ITC hotel. So every time you enter an ITC hotel, you will smell a different smell. So this is a smell that they've concocted, and they use it and they connect it with the trademark. So every time you smell it, you have to be reminded of the hotel. So it's a very good strategy, but it's not yet protected in India. But because the trademark must always be graphically represented, and in your form as well, you have to specify your goods and services under which class you are registering it, and the date of first use of the mark, like when did you first use the trademark, and a user affidavit, which means that you are going to use this trademark for this particular business and for selling these particular products, and if you've been using it before, then you have to show the user affidavit that you've been using this product, this trademark, in relation with these goods and services. Okay, so you must have seen above a few names. There is TM or R written. So TM means that the trademark application is under process. It's on its way. It's been processing and it has been filed, but it has not yet been received. But it's processing. And R means that the trademark is registered. So that's the difference between trademark TM and R. And once your trademark is registered, you can put R on the name. And what are the benefits of registration? So for example, if somebody else tries to use your trademark, or somebody else tries to benefit from from the reputation and goodwill you've earned from the selling the product, then you can if somebody else tries to take that away from uses your trademark as their own trademark, you can stop them from using, because trademarks are exclusive, right? Which means you can stop others from using your trademark. So if you see that somebody else is using your trademark, then you can take legal action against them, and you can file a case, and also draw compensation and damages that has been developed from the infringement. And if your trademark is registered, then you can also assign it or license it to anybody else, because trademark becomes your property. So you can also give it to somebody else and make money from that also. And you can enjoy goodwill as well. I mean, as a registered proprietor, people will associate the product with your company's name, and you enjoy the goodwill of the and also obviously it gives proprietorship to your company. And that's it about trademarks. But I also thought that maybe I should touch upon designs a little bit too, just because designs are very much related to trademarks. Because designs are something that are applied to a product. So for example, you have registered your trademark, you're selling products and everything, but you need to make your goods look different from others, and so that's where industrial design comes in. So design is a shape or a pattern or arrangement of lines or color combination that can be applied to a product. And it's designs are something that's not design is a completely different IPR, but it's very much related to a trademark because its designs also deal with the business of a proprietor. So designs are something that's completely aesthetic. They don't have a function. Their only purpose is to make the product look more appealing and more attractive. So you can see the Coca-Cola bottle here. It's the evolution of Coca-Cola since it was first invented. The bottle was first made. So it has been changed from time to time to time, and now it looks like this. So a design is the shape of the bottle, but it does not have any function. So you can see here the white bottle. It definitely has a different design, but the hole also provides a function of using it as a handle. So when you use it as a handle, it's giving a function. That means it's not just aesthetic, and it's also giving a function. So this will not be, the white bottle will not be registered as a design, but either patent or some other IP right, but not as design because as like with the aesthetics, it's also giving a function of handling. So design's purpose is only to make the product look beautiful and nice, and it's also something that's appealing to the consumers, and consumers really, they get attracted to a product because it looks different and it looks very appealing. So that's the role of designs. And designs are also registered for 10 years, and they can be extended by 5 years, and then you have to keep changing your design. As you can see in the Coca-Cola bottle, they have changed their bottles through the years, and it has evolved in a different design now. So yeah, that's it about designs as well. And designs should not be artistic in nature. They should not be a painting or any sculpture. It should be something that's like, because if it's artistic in nature and like a painting or sculpture, that would cover in copyright. That's another IP right, which my colleague will be covering in the next sessions. So design is something that's completely aesthetic, and it should be an eye-catching feature, and it should be new and original, and only it should be applied in an industrial process. It should be applied to a product. Otherwise, it will not be registered as a design. So that's all from my side. I think, yeah.
Thank you very much, ma'am. And I think there are some questions in chat box. If you feel like you can answer.
Yeah, I will answer. Let me just see.
Like Anamika has a question that trademark should not be generic, but there are funds and petals available in the name. So will they be considered as generic things, or they are just like considered?
Fonts, I mean, it's also very subjective. Like I forgot to mention it. So it's also very subjective to the trademark examiner and registrar. So it should not be generic to them. And sometimes there are cases where actually trademarks do get registered. So it has to be like you should be able to present your case very well. And in that case, you can register. And Fawns and Petal is a very famous trademark, actually. Yeah. So it has been registered. So it's very subjective to the registrar who's registering it. And if they see that it's not very generic in sense of explaining, also it's it's not generic, but what I said about descriptive is it's not. If it's not like if the registrar is not able to connect it with the ferns and petals as in the flowers, then they may register it. But it's like again very subjective.
Thank you, ma'am.
And if anybody has question, please you can ask now. If anybody want to ask question, you can unmute themselves and then.
How much similarity are acceptable? Again, it's similarity as in the new trademark and like existing trademark and the new trademark, I'm guessing. That's your question.
Yeah, I think.
What are the protections available for the person having the original trademark? So yeah, again, so the protections is that it's nobody can use it for 10 years. You have exclusive right on it. And if somebody else infringes it, then you can first you can give them a notice that this is my trademark and you should not use it. And if the person still does not listen, then you can go to the court and present your case that this is your trademark and somebody else is infringing it, and then they can stop the other person from using your trademark, as well as they will also provide you with some compensation or damages that they have earned after using your trademark. So for example, somebody has made a lot of money because they were using your trademark, so they will also give you compensation about how much money, how much profit they've made using your trademark. So yeah, and it expires after 10 years. You'll have to renew it after 10 years. So in IP, we are not in top 30. How are we lacking? That's we are doing our best. I mean, we are registering, we are expediting our examination, and we are providing incentives. So we're not very behind. We'll soon be there. Don't worry about it. And about your question on how much similarity is acceptable, I couldn't say like an exact number, but it comes down to your examination and the trademark registrar's examination of how much similarity can be acceptable. If it's very like sometimes these cases also go to the court in understanding how much similar a product was. Like for example, I gave you the case of theobroma and theos. So the court decided that Theos will only stay in Delhi and Theobroma will expand in the country. But there was another famous case called Starbucks versus Sardarji Baksh. So they were very similar in name. So what happened in that case? The court decided that Sardarji Baksh was not actually infringing the trademark of Starbucks. Starbucks did file a case for this, and the court said that Sardarji Baksh is a different language and it's not very similar. The logo is different. So in that case, nothing really happened in Sardarji Baksh's functioning very well with the name. So it really comes down to the decision of court and the registrar as to like ascertain the similarity of the trademark as how much is it and how much is not. So that's the answer to your question.
I got to know that 30% of different similarity is available as if I got my name entered before God, and somebody else whose name ending with the God, he can also apply the same title, and because 40%, 30% name is similar, so he can work. But if he start before God, excellent or something, then it should not be acceptable. I had the confusion about it. That's why I asked that how much percentage is acceptable or not.
Okay, all right.
Okay, do you have any other further question? Do anybody else want to ask right now?
All clear, sir.
Okay, ma'am, you were saying that even sound can be registered or something, but if as if somebody is singing a song and he registered got the copyright on that, and somebody else is also trying the same song, or some voices are similar, then how they will get that compensation thing, or what protection they are going to get because of their sound is registered?
Sorry, your voice is very breaking. Could you?
Am I audible now?
Yeah, I can hear you now.
If, as an example, you were saying that roaring sound of a lion is registered or got that protection.
Yeah.
Somebody lion is roaring and he got that registered, and how we same question will be there that.
So yeah, again, see, when you register your roaring lion as the same as MGM, so obviously the examiner will examine as to the sound. If the sound sounds very similar to the existing trademark of MGM lion roaring, then this could come into a dispute that this is very similar to the lion roaring. I mean, I understand that lions roars are not very different, like they all roar the same, but because it's very unique and it's very distinctive and one person has already gotten a trademark for lion roaring, then it would be difficult for other person to get it registered as their own trademark. So unless and until there's like a baby cub roaring, or like there's a significant difference between these two sounds, then it will be registered, otherwise it will not be registered. So it all comes down to the examination of the examiner as to how much similarity is there. And obviously there's not only one single examiner, there sits a panel to decide that if it's similar or if it's not.
Okay, do we have any other question? Well, I believe that was all. So thank you very much, Charu ma'am, for this very wonderful session. And seriously, for all of us, now whosoever is working in this IPR field as a teacher or something in another role, or whosoever just student, this session is really going wonderful. And most of the information were new for me or most of us, because like shapes can be registered, even signatures can be registered, as IPR was really new information for me as well. So I believe that all of our guests in this seminar must be getting very much helpful and finding this very informative, this session. Thank you very much, Charu ma'am, for this.
Thank you.
Now
Thank you.
I'd like to invite our next guest, which is Ruchika Singh ma'am. Again, Ruchika Singh ma'am is the manager at CIPM DPIIT. Ruchika Singh ma'am holds a master degree in biochemistry from National Dairy Research Institute, Karnal, and have a post-graduate diploma in patent law in NALSAR, Hyderabad. He has certificate in intellectual property rights, WIPO, science, administration and management, IISCR, and Newton Bahua Funds of British Council India, and publication in peer-reviewed international journals to be credited. I believe Ruchika Singh ma'am is there. Ruchika Singh ma'am, can you hear me? Ruchika Singh ma'am, are you there?
Wait, I'll just check with her if she's online. If you could just give me 2 minutes. Hello?
Sure, ma'am. Please wait for a while. I think Ruchika ma'am is going to connect with us in a few short while. Please be with us.
So Ruchita ma'am is having a little bit of difficulty in connecting to the session. So it will take her 5 minutes. If everybody can wait for 5 minutes, maybe we can chat for a longer bit and we can have a discussion. If anybody has any questions, I'd be happy to answer regarding trademarks or IPRs in general or anything.
Ma'am, please tell a bit more about your department. What your department is actually doing in this field? Like most of parties have already cleared.
Yeah, so our department is actually the nodal point for IPRs, which means that we take care of the laws, of the regulation. If we think that there are some changes that needs to be brought in the act, we do that. Also, we review the acts very regularly. And then our division, which is CPAM, we take care of the taking like awareness programs. So we take awareness programs in universities. We also do awareness programs with police academies because it's very important to teach police that there are these counterfeited products and these pirated products in the market and they should stop people from using it. So as an enforcement agency, police plays a very important role, and like I was saying that it's very important for us to build respect for IP, which means that even if we know that the product is counterfeited or pirated, it's important for us to know that this is counterfeited and pirated and that we should stop not use it. Like we could either otherwise go for any product which is local and genuine, other than chasing the brands and other counterfeited products. So that's something that we are actively looking into, which is the building respect for IP. And yeah,
I had a question. Do we have protection for as an customer as well? Like I'm a customer, I bought a pair of shoes of Nike, but they were not actual Nike. Somebody, it was like pirated copy or something. Then what right I have as a customer because somebody has
yeah, you can see grievance under the Consumer Act. So if as a consumer, everybody should know about the Consumer Act. It's also called COPRA, I think, Consumer Protection and Rights Act. So that's actually a very important act. It's not related to IP, but it's in general, like if like as a consumer, you get some rights to have like quality products and all that. So if you're not getting what you had paid for, then you can go to consumer court, and then you can file a case, and then generally the courts are very like they listen to your problem, and then they provide a solution as well. So as a consumer, like it's not related to IP, but in general, as a consumer, it's your right to have. Yeah, I think they've connected.
So that will be go to consumer court, not the intellectual property right type.
Yeah, exactly.
Okay.
Hello. Am I audible?
I think Ruchika. Yeah, ma'am. We can hear you. You're audible, ma'am.
Sorry, there was some technical glitch here, and I hope I have not too delayed for the session.
Not an issue, ma'am. That entirely okay.
So I just
are you
wanted
okay
to check if my screen is visible to you, if the presentation is visible to you.
Yes, ma'am. It says Cell for Intellectual Property Right, IPR Promotion and Management. Is that your screen?
I will just move the. Are the slides moving?
No, ma'am. There is no. Oh, yeah. It's patent drafting. Is that?
Okay. Yeah. Yes.
Yes, ma'am. I'm sorry I gave that introduction of yours, but I believe that that part is missed from your side.
No problem, sir. Thank you so much
So
for having me. Thank you, Charu.
Hello, everybody. There was really wonderful session going on with Charu ma'am. Now, Ruchika Singh ma'am has joined us and already introduced her. Now, I will hand it over to ma'am so that we get to know more and more information. So, Ruchika ma'am, please continue. And thanks very much for being here with us. Please, ma'am, please continue.
Good afternoon, and I extend a warm welcome to the faculty and the students. So I believe that students have a fair idea of what intellectual property rights are, and I would try and generally touch upon what kind of intellectual property rights we have. And since the session is on patent drafting, I would be taking more delving into more information on patents. So I would request that the students be more interactive. That will help me also deliver an interacting and interesting session. So before moving on to the topic of today's session, which is patent drafting, specification and filing procedures, I would like to know from the students if they know what patents exactly are.
All the students can reply in chat box or they can unmute themselves if they are. Please make it an interesting session. I think they will respond later. You please continue.
Sure. So generally, we have the intellectual property rights are something which come out of the human intellect. Anything which is a fruit of thinking and creativity of the human mind, it is the intellectual property. And whenever we have legal rights attached to those, it becomes our own intellectual property rights. So there are common forms of intellectual property rights, which are patents, copyrights, trademarks, industrial designs, geographical indications, and then of course we have Plant Variety Act and Semiconductor Act, which are not generally used. They are not very often used, but of course, yes, people are realizing the importance of those property rights as well. So coming to patents, why we need, what is the rationale behind having a robust patent system, is to encourage scientific research, new technology and industrial progress. What is a patent? Patent is a limited monopoly right which is granted by the sovereign state or the government in consideration of disclosure of the invention by the inventor. The inventor must provide a complete and accurate public description of the invention in order to enable others to use that information to invent further, thus pushing the technology forward for the societal benefit and impetus. So, the philosophy behind having a patent system is something we call quid pro quo, which means this for that. So in a literal simple language, it means that you are exchanging something for something else. So in exchange of disclosing your invention to the patent office, you are getting a monopoly right for a limited period of 20 years. So once that right is exhausted, the information gets into the public domain. Since the topic today is basically focused on patent disclosure, so specification forms a very, very important part of a patent. And by specification, I mean that there is a legal document which has all the important and relevant details of the invention, and also it has claims to the patent right. So once it has, once you have a fully formulated document, it is only then you can have your rights upon your invention. So why is an specification important? Because it is read by the patent office. It is also used and read by licensee or the assignee, courts in case of infringement proceedings, skilled persons, technical peers, your competitors, commercial players, and general public as well. I'm sure the students, they must have, since this is a digital era, I'm sure they are, looking, whenever they come up with an idea, I'm sure they look for such kind of inventions if they're available in the public domain. And they must have come across several patents. For example, you have drones now, or any other technology, a lot of patenting which is happening nowadays, and it is also available in the public domain. You can have a lot of information from the net as well. So the specifications typically are of two types: provisional specification and complete specification. So provisional specification is a document that just simply describes the invention. It may or may not have claims. You can disclose as much as possible. There is no limitation as such. And you file a provisional application to secure a date of priority. So when we, there is a form 2, the next slide will have that form 2 for your better understanding. There is a preamble to it. So there is a different preamble to a provisional specification vis-a-vis a complete specification. So complete specification is a document which describes and specifically claims an invention. So whenever a patent is granted, it is granted on your complete specification and never on your provisional application. So this is an example. I hope the screen is clear. If you see the preamble of the description, for provisional, it says the following specification describes the invention, while that for the complete specification says the following specification particularly describes the invention and the manner in which it is to be performed. So why do we actually file a provisional application, and what are its advantages? So when you file a provisional application, when you're not too sure of your technology, you think that it is important to have an application filed because you may have several competitors at bay. To keep them at bay, you might want to secure a priority date. But having said that, you are not sure that your invention is complete or your technology is fully developed. So when the invention is conceived but not fully developed, you can go for a provisional specification. Then you may want to, we always say that you should patent, publish, and then prosper. We have seen that the institutes generally, favor publications first, and then they think that they should go for patents, which is not a correct approach, because once you have a publication, your information is already in the public domain. And once
मैम आई थिंक आपकी आवाज नहीं आ रही है. Ruchita ma'am, I think there is some problem. Ruchita ma'am, can you hear me? Ruchita ma'am, can you hear me? I think there is some problem. As she was saying earlier that she was
I'm back now. Yeah.
okay. Yeah.
Hello.
Sorry for the. Please, ma'am. Please continue. Sorry for the inconvenience.
I'm not sure when I got disconnected. Was I on this slide or the previous one?
Now you are good to go, ma'am. We can hear you.
No,
Slide
I
is-
want to know where I got disconnected, on this slide or the previous one.
Previous one, previous one.
This one, right? So,
No, previous one. Yeah. Okay, this one.
okay. So, so there, like I said, that there are provisional specification and then there is a complete specification. So when we are filing the application for a patent, we have to, particularly decide whether we are going for provisional filing or a complete filing, because both have a different kind of preamble. Like for provisional, it says the following specification describes the invention, while for the complete specification, it says the following specification particularly describes the invention and the manner in which it is to be performed. So you can see that there is a change in the preamble. And you will also realize why a provisional application is not a basis for granting of a patent, because it generally describes the invention, while a complete specification is a full-fledged document. So you may want to file a provisional specification when you have conceived the invention, but you're not too sure of whether it is fully developed. You may, want to add on certain elements to the invention, or there may be, something which is not fully developed, but you would want to, take it ahead and file in the first place to have a priority date and to keep your competitors at bay. So India, we follow first to file system. The one who files first has a chance of getting the patent. And we have generally seen that in the educational institutes, people, generally follow the trend of publication, and then they decide to go for patenting, which is not a good approach. The ideal approach is patent, publish, and prosper. So that is the general approach and terminology that we use, the phrase that we use in the patent lingo. So because once you have your information published, it comes in the public domain, it no more becomes a novel. So which defeats the basic purpose of getting a patent, because the core of having a patent is that your information is still novel and it is not in the public domain. So what we generally recommend is that you may not have the technology developed and you would want to submit the thesis or go for a publication. So it is better to file a provisional specification, get a priority date, and then go ahead with publications and thesis submission, and likewise. Sometimes it is also seen that the inventors may be leaving the company, so it is better to file a provisional application so that you have basic information in place and the applicant name is duly addressed in the application. Then sometimes it happens that there is an accidental disclosure. You may have disclosed it to a third party accidentally, or you may have it displayed somewhere in the public. So you can immediately go and file a provisional application to secure a priority date, so that there is no third party who comes and claims seeks a claim on the same invention. So the benefit is that the specification can be amended to add new information at the time of filing, and it is to be completed within 12 months. So you have a window of 12 months before filing a complete specification. So provisional specification is generally a standalone, it's a rough draft. You have enough details to clearly identify the invention. Drawings are mandatory if required to support the invention. However, I emphasize again that it is not the document on the basis of which a patent is granted. We start with the the anatomy of a patent. So it's we have description, then we have claims. So description generally discusses the details of the invention for which the protection is sought, to reflect that the invention is novel, inventive, industrially applicable, and patentable under the Indian patent law. Claims, however, they define the metes and bounds of the patent. The exact, the right which you have on the invention actually comes from the claims, which is the operative part of the specification. And at the time of infringement proceedings, only claims will be interpreted. The section 10(4) of the Patent Act actually defines the disclosure, the sufficiency of disclosure, and it says, and I quote, specifications shall fully and particularly describe the invention and its operation or use and the method in which it is to be performed. It discloses the best method of performing the invention which is known to the applicant and for which he is entitled to claim protection. Disclosure is generally intended for a person skilled in the art to understand and work the invention. Disclosure must describe the invention comprehensively and also support the claims. Enablement should fully explain the problem to be solved with examples so that a person ordinarily skilled in the art can carry out the invention described in it. And then what is the best mode of performing that invention on the date of invention? Title, a preamble, field of invention, background of drawings, abstract, deposits in case we have biological material involved in our invention. So I will just take you through two examples to show you how a patent actually look like. And I think the first one should really, interest you. Is my screen visible?
Yes, ma'am. The screen is visible. It's saying reference patents.
Visible to you?
Yes, ma'am, it is. Saying
Okay.
example to show the patent.
Method and means for creating anti-gravity illusion. Is it visible?
So, ma'am, I think it is showing that PDF file reference to, but it is not exactly displaying the content with much behind it.
Okay, I don't know then how to show it.
You need to open that PDF file.
Yes, I have opened it and it is on my screen.
On our screens, it's just showing as the reference patent, the PDF file, which must have some picture behind it.
Yes. So I don't know why it is not showing.
You can continue without that as.
Okay, this PDF is not visible to you.
No, ma'am. It's just showing to be the PDF file, but it's not opening in the file.
Okay, actually, I wanted to take you through the anatomy of a patent. I mean, how is it? How does a title look like? Then what is the summary? And anyway, I will share this with you later, and maybe you can share it with the students. They can have an idea of how it looks like.
Sure, ma'am. Please go ahead.
So when it comes to title, we have to be very sure that it is concise and it sufficiently indicates the subject matter of the invention. It should not exceed 15 words. It has to indicate the nature of the invention, but does not describe the invention. It could be a product. It could be related to a product or a process or an apparatus. Few examples are when we say toothbrush, toothbrush, of course, is a very generic term. But while we are drafting a patent application, we generally go for technical terms such as a cleaning article or an oral care implement. So an oral care implement having an adjustable mass centroid. That could be a title for a normal toothbrush. So it makes it looks technical. It also, helps in increasing the scope of the invention because a lot of things, can come under this title. Then you have a writing instrument for forming thermochromic handwriting. So the tip is that the title should be brief. It should be well within 15 words, free from fancy expressions, any ambiguity, and it should give a fair indication of the art or industry to which it relates. So like I mentioned earlier that there is a provisional specification which has a preamble which says following specification describes the invention, but the complete specification follows a different preamble which says that following specification particularly describes the invention and the manner in which it is to be performed. Then we have field of information which gives more details than the title. It gives the general art to which the invention belongs, the utility of the invention, and sometimes it is used as a search tool in the absence of an abstract. So this field of invention, it may start with this invention relates to, and then you can go ahead to what it relates to, which technology field actually it belongs to. Is it electrical, mechanical, biomedical, and likewise. Then we have background of invention. The background must clearly bring out the current state of art of the technology relating to the invention. It helps us to identify you also, the background also includes the closest prior art from the patent or the applications, technical literature, books, etc. And this is very important because you have to differentiate your invention from the prior art. So when I say novel, we generally mean that it has to be different from what actually already exists in the public domain. So unless you have, some invention which is a step ahead of the existing technology or the existing prior art, it is very difficult for you to secure a patent. So it may involve unsolved problems, then the prior art solutions may not be working, and your invention is describing a new solution to these problems very adequately. So the background has to bring out all the details about what is the existing technology, what are the disadvantages with the existing technology, and what is the advantage that your invention is providing over this technology. Then there is another concept which is objects of invention. The necessity of the invention is fortified in this section. It brings out the positives of the invention and the essential aspects or the preferred and optional aspects. The general, precursor to objects of invention is that principal object of this invention is so and so. Then there is another object of this invention, a further object of this invention. So this is how you frame your sentences for the object of invention. Then summary of invention, it is actually the most important part of the patent. Because it gives the distinguishing features of the invention. It generally details out the essential novel features of the invention for multiple embodiments, and it is also form of paraphrasing your independent claims in a way that it is actually it gives a summary to your invention. A person skilled in the art can go through the summary and understand what is the invention all about. So again, it is phrased as one embodiment of the invention is, or one further embodiment of the invention is. That is how you start your summary. Then detailed description of the invention. It sets out the best mode of performing the invention. Description sufficient to enable a person skilled in the art to put invention into practice. Describes the invention in greater details with examples, illustrations, tables, graphs, diagrams, etc. You should follow these terminologies which are consistent, should be well organized and easily understandable, and start with a general overview and proceed with increasing levels of detail. Then we have claims. Like I mentioned, that claims describe the metes and bounds of an invention. They actually describe the scope of your invention. The legal rights generally surround the claims. I had mentioned in my earlier slide also that any infringement proceedings that you may have with your patent, generally, your claims are interpreted in those proceedings and nothing beyond. So we start the claims on a different page. The preamble says I/we claim. It has three, the structure of the claim generally has an introductory phase, a transition phase, and a body. So introductory phase introduces the subject matter of the invention. The transition phrase joins the introductory phrase to the body of the claim, and the body defines a particular embodiment of the invention. I have an example here which says a toothbrush, which is an introductory phase, and then comprising, which is a transition phase, because it is attaching your introductory phrase, which is a toothbrush, with the body, which is a handle, a head attached to the handle, the head having a front surface on which a plurality of outwardly directed cups are located, wherein each cup is formed by a central densely packed plurality of first cleaning elements and is surrounded by a second cleaning element located in the form of a ring and many third cleaning elements located around the periphery of the head. ये बेसिकली एक नॉर्मल टूथब्रश का क्लेम है. सो आप देखिए कि एक पैटेंट में किस तरह से टेक्निकल लैंग्वेज यूज की जाती है टू मेक योर इन्वेंशन लुक लाइक it is very different from what is normally existing in the prior art. So I would like to take you through the transition phase because there are two aspects to it. One is an open-ended phrase which says comprising. It could also say including, containing, or characterized by. It does not include additional unrecited elements, and it expands the scope of the claim by allowing other elements or limitations. However, the close phrase which says consisting of, it limits the scope of the claim. So if you have any specifically recited elements, you can only have those specifically recited elements which are in your claims, and you can't add any unrecited element here. So it limits the scope. It covers only elements named and nothing more. Generally, these are used for chemical compositions. So claims should be concise, precise, and accurately expressed in legal terms, defining the scope of the invention. Begins with a broader claims and then develops toward claims that are narrower in scope. Any subjective words like thin, strong, major parts such as when required or any should be avoided here. So we have independent claims and then we have dependent claims. Independent claims defines the essential novel features of the most preferred embodiments. It is standalone, it does not depend on any other claim, and it is usually broad. For example, we can say that a pencil having an eraser fastened to one end, and then it is followed by a dependent claim which is either independent or dependent on another dependent claim. It is narrow in scope and to the pencil on one end using an adhesive. So the important main properties need not be merged into other claim. A separate claim has to be formed for an important feature. I have few examples here to show you how the claims are generally written. For example, a chair comprising a seat and a backrest. Said chair further having 5 legs. So how do you write a claim? A chair comprising a seat, a backrest, and at least one leg. So when we say at least one leg, you have an option of, having more than one leg. So that is how you broaden the scope of your invention. Then there is another example which says a fan comprising a rotating hub and 3 wings attached to the said hub. So the claim would read like a fan comprising a hub configured to rotate and at least one wing attached to the said hub. So when we say at least one wing, then you have an option of having more than one wing. We can have process claims or we can have product claims. Process claims, like the name suggests, it is used for process invention and has to clearly define the steps involved in the process. The product claims could be... hello?
जो पीछे का स्लाइड है आई थिंक वो चेंज नहीं हो रहा है. अभी हम डिटेल्ड डिस्क्रिप्शन इन्वेंशन पे ही हैं. इन केस यू आर शोइंग द पिक्चर, दे आर नॉट विजिबल.
Now?
No, it's still on detailed description of invention. Now some changes are there. I think claim example. No example अब आए हैं. Example सब हो रहे हैं.
Okay. तो ये अभी दिख रहे हैं? Is the slide moving now?
Yeah, now it says types of claim based on
Yes,
subject
yes.
matter. So,
Yes, yes, yes.
yeah.
So we have process claims which are used for process inventions, and they have to clearly define the steps which are involved in the process. And we have product claims which may be claimed as an apparatus, a system, a device, an article, or any other product. For example, an apparatus for cooking rice comprising a means for holding rice and a heater configured to heat the rice holding means. Is the slide moving now?
Yes, ma'am, it is now.
So next part of the anatomy of a specification is drawing, which is again submitted on a separate sheet. They are made on scale sufficiently large to show the invention clearly. Dimensions need not be marked. It has to be sequentially numbered. No descriptive matter is allowed here unless you have a flow diagram or a flow chart. And then the labeling should be consistent. Abstract is a concise summary of the invention which indicates clearly the technical field and the technical problem and the solution that the invention provides. This again goes on a separate sheet and starts with the title of the invention. It should not exceed 150 words. I hope you remember that the word limitation was in the title had in the title. So it should not exceed 150 words. It should include reference numerals and indicate figures that needs to be published with it. I had mentioned in my previous slide that there are deposits which generally relate to the invention, which include biological material. So material cannot be adequately described in the written description. So we need a reference which has to be provided in the specification. It should be made on or before the date of Indian filing. And according to our Patent Act, we have to So there are general do's and don'ts that we should follow while drafting a patent application. We should avoid using jargons and slangs. Not commonly used terms must be clearly and sufficiently defined for the benefit of FOSITA. I have been using this phrase for quite some time now, but we have an abbreviation here. It says person having ordinary skill in the art. Any person who has an ordinary skill in the art should be able to understand the invention. And any terms in the foreign languages must be provided with English equivalents. So the key takeaways are that it's a skill-based drafting. You need techno-legal expertise. It is only one-time chance. You cannot add forgotten or missed out details later. And you cannot get protection for what is not described properly. It is a one-way road. You cannot broaden your claims. You cannot broaden the disclosure and the claims, beyond what is already disclosed. So you don't get a second chance. So you have to be very, very careful about what you are disclosing in your invention. What is not disclosed is not secured, is not protected. So claim drafting is all about precision, clarity, imagination, and foresight. I will again re-emphasize that you have to be very, very particular when you are drafting your application for the reasons I just mentioned. Coming to the patent filing procedures. So what we do, direction that we follow is we do a prior art search, which makes you feel comfortable that your patent is actually novel. There is no prior art related. Nobody has done that invention before. You have an invention which is really novel. So you have done a preliminary search. Now you can go for patent filing. So like I mentioned, you can go for drafting of an application, either provisional or complete. And then once you have decided which application to file, if you have a provisional application, you have a window of 12 months to file a complete application, or you can directly file a complete application. Just quick recap. Provisional specification made even before the full details of the working of invention are developed. This is to secure a priority date. Complete specification, it has full details of the invention and claims. So again, like I mentioned, complete specification has to be filed within 12 months of filing the provisional application. Again, a recap, the contents of an application includes title, technical field, background of an invention, summary, brief description of the drawings, detailed description of the invention, drawings if you have the drawings, claims, and an abstract. So when you're filing an application, these are the forms which are typically required. So we have a form 1, which is a general application of a patent. Form 2, I showed you a draft of form 2 in my earlier slide, which may be provisional or complete. Then there is form 3, form 5, which declares there is a declaration as to who is the inventor. Then form 18, which says request for examination, and form 28. So since you are an educational institute, you can claim the status of an educational institute by filing form 28. This will give you a basic idea of the fee, the form. Actually, initially, educational institutes were not included as a natural person or as a small entity section. So now with recent policy developments, educational institutes are, under the natural person or startup or small entity category. And then we have the other category, which is for the larger corporates and bigger companies. So the fees for form 1 is 1,600 for a startup, small entity or educational institute, and 8,000 for bigger corporates. You are allowed to have a specification running into 30 pages and claims up to 10 claims. Anything beyond will attract an additional fee. Then we have form 18 for examination, which is 4,000 for a natural person or a startup or small entity or an educational institute, and it is 20,000 for a bigger corporate. We also have a provision of expedited examination where, of course, it comes with a fee, but then you can have your, filing and processing. You can have it, streamlined and earlier. If you file we have a concept of early publication as well. You can go for early publication. You can have expedited examination of your application, and the processing is generally faster. So this attracts a fee of about 8,000 and 60,000 for large corporates. I would like to, specifically mention that this process of expedited examination is for startups, small entities, female applicants, government departments. If you choose India as a searching authority while you are going for PCT application, and especially institutions which are established by a central, provincial, or a state act which is owned or controlled by the government. This is important because most of the educational institutes will fall in this category. And then it is generally also applicable to the institutions which are wholly or substantially financed by the government, or there is an arrangement of patent prosecution highway between the two countries. You can't have patent. When you have a patent protection, it is important for you to keep renewing it till the 20 years, because unless you renew it, your patent will get abandoned. So to have your patent for the entire life of 20 years, you have to keep renewing it. And the fee for 3 to 5 years is, like I mentioned, the duration of a patent life is 20 years. So for first 3 to 5 years, it is 800, and then 2,400, 4,800, and 8,000 for maintain your patent. You can choose not to pay the renewal fee, and it will automatically get abandoned. So we have these 4 branches of patent offices in India: the Delhi, branch Kolkata, Chennai, and Mumbai. So there are 4 patent offices. You can file your applications in any of these offices depending on the location. To file a complete specification. In case you choose not to go ahead with your application, you have a window of 15 months where you can withdraw your application. Because once the because after 18 months your application will get published and subsequently examined. So it gets published after 18 months, then there is a request for examination that you can either file along with the filing of the application, or you have a window of 48 months from the date of priority. So once you have that examination request, there is an examination report which is generated. You have to give a reply to the examination report within 6 months, which is extendable by 3 Am I audible now?
Yes, ma'am.
Um, I'm really sorry for the network connectivity this side. So I was on this slide, or okay, let me take you to the patenting process again. So we file a provisional application, then we have a 12 months window to file a complete specification. You have a chance of withdrawing your application within 15 months before it gets published. In case you choose not to go ahead with your application. But in case you want to go ahead with your application, so after filing your complete specification within 18 months it get published, you can file for request of examination along with the patent application, or you have a window of 48 months from the date of priority to file for request of examination. Once you do that, there is an examination which happens and a report is generated. You have to reply to any objections which which the controller may have on your application. You can reply within 6 months, which is generally extendable by 3 months. The controller will offer you a chance of hearing where you can explain the controller as to how what kind of objections he has and how you would like to overcome those objections. Once everything is sorted, the patent is granted. Once the patent is granted, you have a patent certificate and you are the owner of the invention. So with this, I end my presentation. I'm sorry for the technical glitch that I had, but I hope that the students got some kind of clarity on how a patent generally looks like and what are the filing how is the filing procedure generally happens. So thank you again.
The session was really wonderful. Though there was a technical glitch, but still, at times the voice was breaking. But the overall session was really wonderful and very informative. Rather, once again, most of the information was given for each and every person. And I believe if anybody has questions, they can please put the question in your chat box. Letting the filing as well. And if anybody has question, or you can unmute the. Well, I believe that yes. Okay. The session was really wonderful, and I believe everybody getting wonderful information from the session. And now, once again, I will like to invite Provis sir, Mr. Sharma sir, because we are going to release this souvenir on IPR only. And I would like to invite Narendra Mishra sir for this release of and HOD sir, Dr. Vishal Sharma sir, please with us. Now, I will like to request Dr. Prithvi Sanger ma'am for the release of souvenir. Dr. Prithvi ma'am, are you there? Dr. Prithvi ma'am, can you hear me? And you, Professor Sharma sir, Provis sir, who is still with us, and I noticed that he was for your honorable presence with us. I think now Dr. Prithvi is releasing the souvenir. Dr. Prithvi, can you hear me? The topics, the content, and stories is there. It's an online release of our souvenir. We all have worked hard on this.
Hello.
Yes, ma'am, you are audible, ma'am.
सर सोविनियर शेयर किया था, क्या शो नहीं हुआ अभी?
नहीं मैम, तो हो गया है. That online release is done.
Thank you, sir.
Thank you very much, ma'am. And now I would like to see Dr. Ravindra Pratap Rana for vote of thanks for the morning. And let me remind that this is just a morning session, and we will reconnect with us. Vote of thanks. I would like to invite Dr. Ravindra Pratap Rana sir for the end of morning session. Dr. Ravindra Pratap Rana sir, Dean sir, can you hear me, sir? Dean of School of Media, Films and Television. Dr. Ravindra Pratap Rana sir.
शुक्रिया विभोर जी. सेल फॉर आईपीआर प्रमोशन एंड मैनेजमेंट डीपीआईआईटी मिनिस्ट्री ऑफ कॉमर्स एंड इंडस्ट्री की तरफ से यहाँ इस वैल्यूएबल सेशन में हमारे साथ एक्सपर्ट के तौर पर जुड़ी रुचिता सिंह जी, मिस चारू जी और आईआईएमटी यूनिवर्सिटी के प्रो वाइस चांसलर और रेनाउंड एकेडमिशियन प्रोफेसर एसडी शर्मा जी, डियर स्टूडेंट्स और माय कोलीग्स. ये बहुत ही एक शानदार मौका था हम लोगों के लिए जब हमने नेशनल टेक्नोलॉजी डे पर ये सेमिनार किया है और सेल फॉर आईपीआर प्रमोशन एंड मैनेजमेंट ने अपनी कंसेंट दी इस वैल्यूएबल सेशन के लिए. हम आभारी हैं विशेष तौर पर रुचिता सिंह जी के, चारू जी के और काजोल जी के कि उन्होंने ये कंसेंट दी. उनकी हायर अथॉरिटीज ने कंसेंट दी और हमारी यूनिवर्सिटी के हायर अथॉरिटीज ने भी इसके लिए जैसे ही हमने ये प्रपोजल उनके सामने रखा तो तुरंत कंसेंट दी उन्होंने. और बहुत वैल्यूएबल रहा पहला सेशन हमारे लिए. हमारी विजनरी वाइस चांसलर प्रोफेसर दीपा शर्मा जी के हम बहुत आभारी हैं कि उन्होंने इसके लिए जरूरी रिसोर्सेज अवेलेबल कराए और कंसेंट दी. हमारे प्रो वाइस चांसलर सर, उनके बहुत आभारी हैं हम. पहले सेशन में यहाँ पर एक्सपर्ट्स ने बताया कि आईपीआर कितना वैल्यूएबल है और हमारा जो इनोवेशन है, हमारे जो इनोवेटिव आइडियाज हैं उनको दुनिया में एक अलग जगह कैसे मिल सकती है, कैसे हम पेटेंट करा सकते हैं, कैसे डिजाइन पेटेंट करा सकते हैं, कैसे ट्रेडमार्क का पेटेंट करा सकते हैं. तो इन सारे इश्यूज पर हमारे स्टूडेंट्स को ही नहीं वरन हमारे फैकल्टी मेंबर्स को भी बहुत वैल्यूएबल इंफॉर्मेशन यहाँ पर मिली हैं. मुझे भरोसा है कि बहुत ही कारगर होंगी हम सबके जीवन में इंफॉर्मेशंस. और डॉक्टर पृथ्वी जी ने बहुत मेहनत से सोवेनियर तैयार किया और पूरा कोऑर्डिनेशन किया है. मैं उनके प्रति भी बहुत आभारी हूँ. इस पूरे सेशन में हमारे लगभग 13 पीएचडी स्कॉलर्स भी जुड़े हुए हैं और अलग अलग जगह से, दिल्ली से, यूपी से, आसपास की कई और लोकेशन से यहाँ पर जो जुड़े हुए हैं साथी, मैं उनका भी बहुत आभार व्यक्त करता हूँ. हम दूसरे सेशन में, टेक्निकल सेशन में बहुत सारे पेपर्स पर डिस्कस करने वाले हैं यहाँ पर. तो मैं उम्मीद करूंगा कि आप सब दूसरे सेशन में भी अवेलेबल रहेंगे. और विशेष तौर पर प्रोविसी सर का मैं बहुत ही आभारी हूँ कि वो लगातार पूरे सेशन में जुड़े हुए हैं. बहुत ही वैल्यूएबल डिस्कशन हो रहा है यहाँ पर और उनकी प्रेजेंस से हमें एक ताकत मिल रही है इसको और बेहतर बनाने के लिए. धन्यवाद विभोर जी.
थैंक यू वेरी मच सर, एंड सीरियसली दिस वाज एन ऑनर कि प्रोविसी सर ने हमारे लिए इतना समय निकाला. थैंक यू रुचिता मैम फॉर दिस वेरिएबल इन्फॉर्मेशन, एंड सीरियसली आपको आज आपका समय हमें मिला, उसके लिए आपको और आपके डिपार्टमेंट को बहुत बहुत धन्यवाद. और हम दोबारा कनेक्ट होंगे साथियों, मेरे सभी साथियों. हम अभी एक छोटा सा ब्रेक ले रहे हैं लंच के लिए. 2 बजे आप लोगों से अनुरोध है, आई वेलकम यू ऑल वंस अगेन टू जॉइन अस एट 2 p.m. after this lunch break. And then Kajol ma'am will be with us. She is assistant manager on CIPAM. So please do join us once again at 2 p.m. Now we are taking a short break for lunch break. Thank you everybody for joining with us. Thanks.